Everything allowed. No separate mention. Everything is allowed. Only don't worry. Only thing adjournment if anybody objects will focus. Item 1. Item 1 please.
Item 1 for withdrawal.
Yes, withdraw. Any reason to be stated? No. Sorry. Please don't disturb. Take it up with the courtmaster, whatever you can. Only. No reason to be reported. Mr. S.U. Ahmed, when counsel for a petitioner states that there is an instruction from the writ petitioner not to press with this writ petition any further. In view of such statement, writ petition stands closed on being not pressed. Any liberty? Liberty granted to approach again, it's so advised.
Item 2 for motion.
We have rejected your adjournment. Mr. Ahmed, we are rejected. We are taking it out. If allowing is not accepted, we are rejecting it straight away. It will be called. Yes. Yes. Page 31. Yes, Mr. Other 2 reasons applicable. No, applicant was underage at the time of death. There is no law that if a person is underage at the time of death, you can never apply. And lately applied, definitely that. What was the judgment? Said Khadim is applicable. Send it back. Third, Mr. M. Polital and counsel for a petition. Also heard Mr. G. Table and counsel. Addition sitting an advocate for the Deputy Commissioner Lakhimpur, as well as the Chief Secretary to the Government of Assam, Mr. M.S.N. Fukan for the respondents in the Education Elementary Department. The mother of the petitioner, Joyashree Sargari, died. Sargari, who was an assistant teacher in the Singhi Doloni Boro LP School, died in harness on 13/3/2009. At the time of her death, the petitioner was aged about 16 years. After attaining majority, the petitioner made an application for compassionate appointment on which date? 22/7/2014. As per the order dated 12/5/2022 of the Deputy Commissioner Lakhimpur, the application of the petitioner was placed before the DLC of Lakhimpur district in a meeting of 34/2022. But it was rejected on 2 grounds: that the application was lately submitted and that the applicant was underage at the time of death of her mother. As regards a late submission of application by a person who was a minor at the time of the death of the employee, the law had been settled by the Supreme Court in Khadim, wherein it is provided that a minor can also apply for compassionate appointment upon attaining majority, provided the other conditions for eligibility for compassionate appointment are fulfilled. But there is no law as such that a person who was underage at the time of the death is prevented from applying for compassionate appointment at any future date. In view of the above, as both the reasons for the rejection by the DLC are untenable in law, the rejection by the DLC in its meeting of 34/2022 set aside, matter remanded back to the DLC to be placed before the next available DLC looking for district for a fresh consideration.
Item 3.
Yes, Mr. Mujumdar. Sorry. John was a pair of the response. What's the issue, Mr. Mujumdar?
Usually related to because you need a grade 4 or you are selected for grade 4 employee. Accordingly, the selection was called up for getting the report of the medical board as well as the person.
She was selected, but the medical board report was not there.
His name was not in the list. The people who were shortlisted, they were supposed to go for medical check.
Okay.
That was a list. His name was not there because of which he could participate in that.
But how did he got selected if his name was not there in
He
that
was
list?
selected. Pursuant to that, the Social and Welfare Department for re-verification again asked all the selected candidates to appear for just to get the assessment of the disability knowledge. So his name was not in that list.
To understand, if the name person's name was not in the list, how did he get selected? Mr. Mojumdar said he got selected. So without being in the list, how did a person get selected?
His name was there, and then subsequently.
Okay, in the select list his name was there, but in the list provided for candidates to appear for health checkup, it was not there.
It was not there, so his name was left out because of which his name was not considered.
Okay.
So
So later on it was considered,
there was a direction by the school to consider his case matters.
and you have the report.
That report we have.
Yes, good case for which department? Education. Madam Fugan, let your authorities take note of this health report and you take your decision.
So the report is.
Okay, we'll keep it on record. Heard Mr. K. A. Mujumdar, and counsel for the petitioner, also heard Ms. M.S.N. Fugan, and counsel for the elementary education department, Mr. A. Chalia for the health department. Who are respondents number 5 and 6? Son of 5 and 6. No, who are they? 5 and 6. For the respondents number 5 and 6 in the Social Justice and Empowerment Department of the Government of Assam. The petitioner Altaf Hussain Bolmia participated in the selection process. For which post?
For grade 4
For a grade 4 post as per the advertisement dated. Where is the advertisement? That is the date. As per the advertisement dated 25/3/2022. You applied under the PWG quota.
Disability.
Okay, that's same thing. PWG, persons with disability. It's nothing different. You applied under that quota. Okay. In the same selection process, the petitioner offered his candidature under the persons with disability quota. It is. Where is the select list?
My name is page
48.
48. Serial number 12.
As per the select list available, as per what is the select list?
Page 40.
As per the order dated, what is the date? 35/2023 of the Director Elementary Education Assam. The name of the petitioner finds place in the select list under the serial number.
Serial number 12.
It's not rated PWD.
Lordship is written there. MPS Lordship Department of Government Services and Department of Services.
Anyway, under the rules, there was a requirement for the petitioner to be placed before a medical board to be constituted by the health department to assess his disability. But in the list that was forwarded to the health department of the selected candidates for undergoing the medical examination, the name of the petitioner is stated to have not found its place. Accordingly, the petitioner was not subjected to medical assessment, and therefore no appointment had been issued in his favor. In the aforesaid circumstance, this writ petition is instituted by the order dated 21/8/2023. There was a direction to place the petitioner before the appropriate medical board for assessment of his disability. Pursuant thereto, a medical report has been produced before the court dated 28/8/2023 of the principal cum chief superintendent, Guwahati Medical College and Hospital, which provides that this locomotor disability of the petitioner was assessed to be 45% due to limb girdle muscular dystrophy. As the petitioner in the meantime had been subjected to the medical board and his disability had been assessed, we remand the matter back to the Director of Elementary Education Assam for taking appropriate decision on the appointment of the petitioner. And in doing so, the medical report dated 28/8/2023 be also taken note of.
The Social Justice and Empowerment Department were the ones who notified that action has been.
I think it's good enough. His name is not there. Now later on it is not there. A copy of the medical report kept on report. Yes, I can go. Mr. Kolita, what is it? What instruction? Was it placed before DLC? Sorry. No, was it placed or it was not placed? It was placed in 2008. What happened? No, court wanted to know whether concerned authorities had placed the application of petitioner before the concerned DLC. So if it is available in page 38, why that order was passed? Page number 13. Report on the proceeding for appointment of 39 years. Who is he? Reason das. Sorry. Page number. Here. Spent force. Spent force. What do you mean by spent force? Firstly, tell us where is the force? To be spent force, there must be a force. Where is the force? Sorry. If it is not placed, if it is not placed, no, where is the Supreme Court? Supreme Court never said 2 years. It is only in that Achut Ranjan Das or that Fazilun Nasser, one line is there, and that has been interpreted to be a directory provision, not mandatory. It's not like a limitation act that one day over everything was. It's nothing like that. Do you mean to say that if the application is not made within 2 years, the financial condition of the family improves after the second year, so that there is no further requirement of compassion? Are the authorities of that view? No. You assess it. But now again, Mr. Polita, it's 2008. Why are you now before the court? 50 years. You file an affidavit regarding stating about your financial condition for the last 50 years. No, we are not concerned with arbitration. We are concerned with compassionate. The application of the compassionate appointment stood rejected by the concerned authority in the year 2008. In order to explain the delay in approaching the court of almost 15 years, the petitioner to file an affidavit stating his financial position for the last 15 years from 2008 to 2023.
Item 5.
Yes, Mr. Doctor. No, what is your matter? Why, Mr. Question? The respondents in the elementary education department to provide the information to the court as to why the appointment letter had not been issued to the petitioner in spite of his services being provincialized. Please consult.
Item 6.
It's not there. Yes. The merger, amalgamation. Now, what is the difficulty?
But they are the provided for selection.
Why?
Because the failure is
So now this is a high school or a higher secondary school? High school. What is the qualification of a headmaster of a high school? It's a casual statement, all qualified. What is the qualification? Let us take a look. Which rules? Sorry. Page, page number.
Page number -37.
Recruitment for the post of headmaster or assistant headmaster. That is page 14, right? See, this is what we are trying to ask you. Shall be filled up from amongst the graduate teachers. Number one. Is the petitioner a graduate teacher? Why? Where is your appointment letter? Let us. Where is your appointment letter as a graduate teacher? No. Receiving same scale of pay may not make you a graduate teacher. Graduate teacher is a defined concept under the rules. So if you satisfy that meaning of a graduate teacher, you are entitled. Mr. I understand your problem. There is a difference between a teacher having a qualification of graduate because of that being given a graduate scale and a graduate teacher within the meaning of the rules. It's a difference. Where is the definition? So we'll issue notice, we'll hear you. It will take a long time.
So when proposal is concerned, they have basically used the get some petitioners, they are total notice. Where they have from different state of it. The observation cannot be the same.
Sorry. The number of the petitioners. But the graduate teacher list is district wise. You fetch per petition. How can you determine? Mr. Saikia, your common grievance should also lead to a common judgment, but we'll have to deliver separate judgments in one rate petition. Petitioner, it stated that the cause of action of all the petitioners is that their names had not been forwarded for being considered for promotion to the post of headmasters of their respective schools. Mr. SMT Chief Steel and Counsel for the Secondary Education Department points out that the writ petitioners are from different districts. Rule 14 of the Assam Secondary Education Provincialized School Rules 2018 provides that the post of headmaster of a high school and superintendent of a high madrasa shall be filled up by promotion from candidates amongst the graduate teachers as per district-wise seniority list on the recommendation of the district selection committee. As the entire selection process is district-wise, we are of the view that different repetitions from teachers from different districts filing a common repetition would be a misjoinder of parties. In view of the above, repetition clause, liberty granted to file appropriate applications. File it together. If for others you are going for a next day, fine, get it day after tomorrow. We'll take it up. Monday. If you have urgency, make a mention, we'll take it up. If there is actually urgency. Otherwise, you will have to write 7 different judgments for 7 different districts, because everything will depend on the facts of the case. And understand. Next slide. Mr. Goswami. SLC rejected. Okay, you are. The respondents say to the Chief Secretary and Deputy Commissioner, which district, Lakhimpur, to provide the information to the court as to whether the recommendation made in favor of the petitioner by the DLC of Lakhimpur district in the meeting dated 24/2/17 had been placed before the SLC for its consideration. Yes, maybe.
I want similar order.
Similar order like?
Yes. Actually, commissioner appointed.
No, similar order like whom?
Similarly, recipient person already been appointed before the
Madam, that's a vague statement. With whom similarity and how similar? So it's better you argue your own case. It'll be faster.
But commissioner appointed as a community authority and teacher training in the year 2004.
Okay.
They have completed 10 years. Then they appeared before the CAT, but they disqualified. Again, they have approached before the concerned authority to conduct a press for their mother. Then they have wrongly.
Now, was the fresh step Porika held or it was not held?
Not held. They have.
So now, what is the order of the earlier order of the court?
That we have wrongly make representation before the election department, election minister. Instead of election minister, we should file before the secretary to the assessment.
So do it.
Yes, ma'am.
Why do you need an order for that? It is stated by MSK David and counsel for the red petitioner that the representation for ventilating the grievance of holding a fresh TET for the red petitioners are actually required to be filed before the secretary to the government of Assam in the school education department and not before the minister before whom the earlier application was made. It is stated that in a similar circumstance, by the order dated 23/6/2023 in WPC, case number. In which case the earlier order was passed? In WPC 3667/2023. The court had allowed the red petitioners therein to submit such a representation before the secretary. In view of the above, the present red petitioners are also given the liberty to file appropriate application before the secretary to the government of Assam in this school education. With the above observation, red petition closed. If any such representation is filed, the secretary may pass a reasoned order within a period of 1 month thereof.
Item 9.
DK Gogoi. Yes, Mr. Gogoi. Was it placed before DLC? So when was it? Want of vacancy? 2018. What is page 37? What is page 37? Okay, you are comparing with somebody else. Now, where is your rejection? Page number 20. Page 23. Who is the petitioner? Sorry, yeah. This is what a vacancy in which department? Education. The education department will approach the other departments under that one. If any vacancy, place it. Consider.
Otherwise, they have not solicited.
I heard Mr. D.K. Gugoi, learned counsel for the petition. Also heard Mr. G. Pegu for whom Deputy Commissioner Nogam, and Mr. U. Sharma for the elementary education, for the secondary education department of the government of Assam. The father of the petitioner, Podum Soikia, who was a grade 4 employee in the Jing Girls High School, Nogam, died in harness on 24/12/2013, and on his death, the petitioner submitted an application for compassionate appointment on 28/4/2014. As per the order of the Deputy Commissioner dated 3/3/2015, it is provided that the DLC in its meeting of 9/1/2015 had rejected the application of petitioner for want of vacancy. It is to be understood that while the application of petitioner was considered, no vacancies were available for compassionate appointment in the education department. As per clause 15, Mr. Pegu, clause 15. As per clause 15 of the OM dated 1/6/2015, there is also a requirement that in the event vacancies are not available in the department under which an application for compassionate appointment is considered, the department concerned to also explore the possibility of availability of vacancy in any other department. In view of the above, the secondary education department, through the Director of Secondary Education, is directed to explore the availability of any vacancy in any other department in respect of Nagaon district. If the information received would be that any such vacancies, that some vacancies are available in some other department, the application petitioner be again placed before the DLC of Nagaon district to be considered along with the information of availability vacancy as may be provided. This will direction. Yes, right. Was it placed before DLC? Never placed. Placed. Okay, list next week for an information by the respondents in the Deputy Commissioner, which district? Lokipur, to provide the information as to whether the application petition was placed before the DLC. Responsible.
Item 12.
Yes, item 12, Lohit Gogoi. None appears for the petition on this thing.
Item 13.
What is yes, 40. Go back to the SLC, consider Khadim's judgment of the Supreme Court. I know it is applicable. Third, Mr. M. Shalim, the counsel petitioner, also heard Mr. P. Sakia, your additional senior advocate, junior advocate for the only four. You have not made the SLC a party. Which is there. For the respondent, for the Chief Secretary to the Government of Assam and Deputy Commissioner Dorong. As well as MS Phuka for the respondents in the Secondary Education Department of the Government of Assam. The father of the petitioner, Bongsidhar Dekar, who was a Chokidar grade 4 in the Dekargaon ME School in the Dorong district, died in harness on 11/11/2007. And on his death, the petitioner, now upon his death, his wife Anupama Devi, who had read up to class 10, had applied for, had made an application for appointment on compassionate ground against a post of Chokidar that had fallen vacant upon the demise of her husband before the departmental authority. But the application of the mother of the petitioner was not given its due consideration. In the circumstance, the petitioner, upon who was aged about 14 years at the time of the death of the father, made an application upon attaining majority. The said application was given a favorable consideration by the DLC of Dorong district in its meeting dated 5/7/2022. But when the same was placed before the SLC in its meeting of 2/3/2023, it stood rejected by providing that the candidate had made an application at the age of 21 years, 4 months, 3 days, as on 23/2/2022. And was 14 years, 3 months, 12 days at the time of death of the deceased government employee. The law in this respect has been settled by the Honorable Supreme Court in its judgment in the Khadim report. So, wherein, in a factual situation where the wife of the deceased employee had made an application for compassionate appointment, which was not given its consideration, an application subsequently made by minor son and daughter of the deceased employee upon attaining majority would be maintainable in law. The reasoning of the SLC is in conflict with the proposition laid down by the Supreme Court in view of the above. The rejection by the SLC in the meeting is set aside, remanded back to the SLC to be placed for its next meeting for a fresh consideration by taking note of the law laid down by the Supreme Court in S. Khadim Supra. Okay. Yes, we lost for yes. Legal heirs of the landowner of. Sorry. Continue, please. You were the legal, just a minute, legal heirs of the landowner. Landowner. So now what is your grievance? What is the condition? Where is that agreement? Page number.
Page number 10. As per resolution, last paragraph, in the case of closure of the school for any reason, the legal heir of the owner will have possible ownership rights of the rights over the connected landlord, and if any one of the
So why don't you go for a civil suit? I think civil suit, because by virtue of this clause, a legal right accrues to the legal heirs of the donor for possession and ownership of the right. Just you think about it today. We are adjourning it, taking up next week. You think which one will be more appropriate? Because in writ, what kind of order can we pass? Because we cannot determine your possession and ownership in a writ petition. Representation, okay, you consider that we can do. That we can do. Yes, Madam, what do you say? The school has closed down. But it is not closed down. Now this land becomes the property of the amalgamated school. Understand, the original school has not closed down. It has become part and parcel of the amalgamated school. Now it will be the property of the other school. After amalgamation, school doesn't cease to exist. It exists, but merged with another one. Maybe. But when Netaji becomes something different, the legal entity remains. Only the identity is changed. It's not a meaning that the legal entity has disappeared or become non-existent. Think about it. It is difficult. Adjourn on the prayer of Mr. H.L. Oscar and counsel for the repetition. List again also.
Item 15.
Action mark. You are a selling respondent number 6.
Yes.
And actually, according to you, the
name has not been forwarded by the master of this.
so who is the petitioner?
Petitioner name has been forwarded, but his name has not. And the inspector also nominated the name of the respondent number 6.
Okay. Now, where is the forwarding and where is the nomination?
Page 32, madam. It's been forwarded
By the school.
by the headmaster.
Who is you? How do you?
I am.
Which reference and list of you can and where is the
That's
appointment?
Page 35.
35. Some Abhijit Bora.
My. His name is not here. Page 35.
And what is the procedure?
It is not exonerating my lord.
Mr. Sharma,
My lord.
what is the law governing the appointment?
That lordship I have managed my lord. That lordship will find. It is notification my lord dated 24/6/16. Lordship will find page 42.
And what did the inspector do? What's an inspector?
After consultation with the forwarded the name.
No, just a minute. Heard Mr. R. Sharma, Land Council for the listing.
My lord, there is partial modification on the now that modification.
Understand? But even if it is so, it is the inspector who has made the appointment, not the deputy commissioner. Come to page 37 and page number 32. No, not 32. Come to page 37. Understand, but who has signed it? Inspector. So it is not the appointment by the deputy commissioner. Where is it? No. So, no, you are incorrect. Page 42. The inspector of school, after consultation with principal, will forward to names. Inspector will only forward, he will not appoint. After considering names, director will provide the list to the government with his comment, and the government will appoint. Okay. Now, if this is modified, deputy commissioner is empowered to select. So anyway, it is deputy commissioner, not the inspector. Heard Mr. R. Sharma, land counsel for the petitioner, also heard Mr. P. Saikya, land counsel for the deputy commissioner. Which district? Nagaon, and Mr. U. Sharma for the secondary education department of the government of Assam. In respect of appointment of president of the Nalarpar High School in the Nagaon district, the school authorities to the headmaster stroke secretary of the school had forwarded 3 names for the president of the SMDC of the school, namely Sheikh Habibur Rahman, MD Mohtab Hussain, and Panjit Bora. By the order impugned, dated, undated, which is undated but available at page 37 annexes 6 to the petition. Abhijit Bora had been nominated as the president of the, what is the name of the school?
Page 35, my lord.
35. And had been nominated as the president of the Nalar SMDC of Nalarpar High School. The appointment of Abhijit Bora, who is a rated respondent number 6, is a sealed in this petition. Mr. R. Sharma, land counsel for the petitioner, relies upon the provisions contained in the notification dated 24/6/2016, which provides for the selection process of president and vice president of SMDC. As per the said notification, the inspector of schools, after consultation with the principal, headmaster, and local people, would forward 2 names to the Director of Secondary Education Assam, each for the president and the vice president, with the recommendation of the deputy commissioner within a period of 30 days. After considering the names, the Director of Secondary Education will provide the list to the government with his comment for selecting a name. It primarily appears that the procedure adopted by the inspector of schools Nagaon appointing the petitioner is in deviation of the procedure provided in the notification dated 24/6/2016. Mr. P. Saikya, land counsel for the deputy commissioner Nagaon, in course of the matter being taken up, has produced another notification dated 27/10/2021 of the principal secretary to the government of Assam in the secondary education department, which provides that in partial modification of the guidelines for constitution of school management and development committee of SMDC, the deputy commissioner of the district is empowered to select the president and vice president of an educational institution. Even if we accept the modified provision of the notification dated 22/10/2021, if prima facie does not appear that the requirements have been satisfied as per the appointment made by the inspector, as available in page 37 annexus 6 to the petition, in view of the above, the appointment made under annexus 6 page 37 shall remain stayed until further orders. Issue notice written over 6 weeks, extra copies 3 days, steps on responder 5 and 6 raise the first 3 days.
16.
Honestly, you do whatever you do, or you correct it. However, issuance of notice shall not preclude the respondents to adopt the correct procedure as provided in the aforesaid notification for appointment of the correct. We give you that liberty. Yes, next time.
16.
DLC. Page number. Same issue. Go back to the DLC. Good, Mr. And in for me, I also heard. See, Mr. Saikia, this compassionate confidence. Firstly, you look with some compassion. Secondly, give a due consideration. Due consideration is interstate comparison of financial status. Instead of doing what is required under the law, you are doing everything else. These are not civil cases where you go for all kinds of technical reasons. By excluding one person in this manner, he may be financially worse off. You reject him. What you do in lieu of that, you give a person who doesn't deserve a compassionate appointment. Is it not so? So that's why we are little severe in these things. Not severe, actually, we are taking it in a more stricter manner. You are giving to an undeserving man. More than rejecting the deserving person, one undeserving person is getting the benefit. When you do that, there is a possibility of arbitrariness and pick and choose. Today you find the name of 15 people, first you choose whom to give, then you think how to reject the others. This is where the trouble is. If you continue, we are going to may order an inquiry by some on this why this is happening. That is the only consideration, compassion. Whosoever family is financially worse off will be given a job. Naturally, applicants will be more, available jobs will be less. So you give it to the worst of the financial family, that's all. More and more you come into these technicalities, you are rejecting some otherwise financially worse off deserving people and giving it to a financially better off person. And the only thing we can understand in doing, you are adopting the method of pick and choose. That means something more is there. And the reports that are coming from the ground level are not very friendly to the government, I'm telling you. There are a lot of manipulations in this thing. It's almost like an industry now. Therefore, that's why first you select the man that we will give appointment to X because he must have favored you in a better way. And then think about how to reject the others. When you pass this kind of orders, in one of these cases, we are going to pass a more severe order against you. We are warning. Ask the people to be more careful. One exemplary order will be passed in one of these cases. We'll call for now, in this case, data will produce the complete records of this case. Which financial layer we want to see along with the applications. The respondents, Deputy Commissioner Hailakandi, to produce the complete records of the DLC dated 5/10/2021, along with the complete reasoning of all the candidates, plus the application forms containing the financial information of all the candidates who were considered. This next thing. Order to Mr. Peace. Okay.
70,
With that, time has come. Is which page? 36. Where is the illegality? Sorry, page number 30. 36. What is this? Informative as a resolution. That also, so SMC for is hereby approved.
And resolution will under this tenant resolution. And that order was passed.
No, on what ground you challenge this one?
Under page 9, there are 6.
We'll go to page 9, para 6. On what ground you challenge?
Ground minus at least 70% members should be present in the meeting.
Okay, where is the provision?
Provision will highlight tenant guidelines.
Page number.
Guideline page number 39. And operating policy page number 41.
It's number 39, operative 41. Meeting shall be organized in a convenient day so that at least 70% parents of the school. Suppose the parents don't go, then what will happen? See, suppose more than 30% of the parents decide we are not going to the meeting. Then what will happen? Will there be no managing committee or still there can be managing committee? What do you say? He is right saying that at least 70% of the parents remain present. Because parents, you cannot compel them to come to the meeting. Suppose more than 30% parents feel that don't bother me. I have some better work to do. I'm not interested in all this managing committee and all. I am only interested that my son should get a good education. That's all. Who is SMC? I am not bothered. Can you compel the parent to come? No. Suppose they don't come. Is it a case that this school will never have a managing committee? Notice also not issued. Notice issued. No, notice cannot be given to all the hundreds of parents. It must be in a public place only, in the school. Visual notice will hear it in written response. I think staying will not be very proper.
In this case, that in fact, the respondent is collaboration with the semi-inherited person, not interested with the academic.
Who is the Rehanuddin?
Rehanuddin is the president of 6.
That the president
The president.
is semi-literate. What is his qualification?
In fact, my lord,
What is his qualification?
qualification, what is my knowledge is 8%.
8 pass. What is the required qualification under the rules?
There is no such qualification. That is the guidance. But there are many learned persons.
Nothing is there. Even an illiterate person can become the president. But he will be doing works related to some academic activity. It's not that you need only a very good manager. You need somebody who understands the academic requirements. If the man himself is illiterate, what will he do?
Requirement is that this will be selected and created by
What do you do in this case? Firstly, his grievance is only 48% attended, where as per the notification he showed, it must be 70%.
And the area from the parents and guardians member only, and of this one be
Oh, men is okay, but no go. No qualification. Now here what we do?
70% of the same so that at least 70% of the
At least that is minimum. So what do you do? You stay. But if I stay, the school will suffer.
and I'm a committee with works. That is
That cannot be.
the school might have been
No, earlier committee we are not a project.
the respondent can run the system.
We are rejecting stay because of balance of convenience that the school without a managing committee will suffer. Who should be president will decide it later on.
At least now the DO can run the system.
DO has lot of other works. SMDC work is a day-to-day work. How can the BO every day go to the school? To one LB school? You have to bear with it. Prima facie case, yes. Balance of convenience, no. Otherwise, the school will suffer. We have noted your case, but we have to decide it fast. We have to give a early hearing. That Mr. H.R. Chaudhary, then counsel for also heard MSN Kuban, then counsel for the Elementary Education Department. Steps on respondent number 5 and 6 by register post as well as by Dusty to the registry of report and thereafter file affidavit. The petitioner are aggrieved by the constitution of the school managing committee of 72 number Borobari LP school in the Karimganj district, in which the respondent number 6, Rehanuddin, had been appointed as the president of the school managing committee. Mr. H.R. Chaudhary lent on the petitioner reference to the notification dated 3/8/2011, which provides that for selection of the president and member of the SMC, the meeting shall be organized in a convenient day so that at least 70% of the parents of the students of the schools, adult members of the respective village/ward of the school, and the official members to be inducted in the committee shall remain present to take part in the proceeding. It is contended that in the process of appointing the respondent Rehanuddin as the president, the number of parents that were present is stated to be 48%, which is far below the required 70%. It is also stated that respondent 6 Rehanuddin has education only up to class 8, and therefore, although no educational qualification has been prescribed under the rules for the post of president, but a person who himself is not fully what is the education qualification of a teacher? LP school, higher secondary. Keep over line.
She's also still in education only up to class 8, and therefore although no educational qualification has been prescribed under the rule for the post of president, but a person
who himself is far less qualified than the required qualification of a teacher would be inappropriate to hold the post of president. We'll decide this issue. I think some qualification maybe will suggest. The submission of Mr. H.R. Chaudhary requires a due consideration, as the president of a school managing committee would be discharging functions which are related to an academic institution, and it is academic institution. But however, in spite of being satisfied with the prima facie case being made out regarding the participation of the number of parents in the meeting through which the president had been selected, but considering the balance of convenience, we are not inclined to pass a stay order restraining the school managing committee from its daily functioning. But at the same time, we are also provide that the issue requires a serious consideration. List on so-and-so. In the meantime, the respondents in the education department to file their affidavit, to positively file their affidavit on both the issues as to what would happen to a school managing committee which is elected or selected, where the percentage of participation of the parents is less than 70, and where a president who is not duly educated is selected as a president. List on so-and-so. Further orders to be passed, if necessary, in the nature of an interim order shall also be considered on the next day. Next day you ask Mr. Gogoi, does the name of any other council appear along with Gogoi? Only Gogoi. Adjourn, next page.
Item 19.
19. Where is the DLC? DLC resolution. Page 16. What is the name of this man? Obidullah Gaspar. Where is the page 16 DLC?
Page number 8, point number 3. Point number 3. Initially, my name was recommended by study, but later on, the SSC state as a committee rejected my case.
Recommended. Then SLC, what happened?
SSC, they rejected the
Page number.
On to page number 24. Point number 4, and serial number 3.
Norms as per OM data means?
Yes. Then after 1 year. But I was a minor.
Minor.
Yes,
What is the date of death?
that is 2012.
2012. When was the application made?
Application made 2016 and 10, 2016.
Your name?
It's
H.
A. Sarani.
E.
A. Sarani.
Sorry. Yes. Same. The father of the petition. What's the name of the father? Name of the father, Jainul Abidin Bhaskar, who was a teacher of Katipura ME Madrasa in the Kachar district, died in Hanes on 13/12/2012. And on his death, the petitioner submitted an application for compassionate appointment on 10/10/2016. It is stated that at the time of death, the petitioner was aged 16 years, and thereafter, upon attaining majority, he had submitted the application in the year 2016. The DLC, in its meeting of 2/2/2022, had recommended the petitioner for the post of assistant teacher in a LP school. But when the same was placed before the SLC in its meeting of 26/8/2022, it stood rejected that the application was made after 1 year. The law in this respect has settled in the bulletin where it is provided that if at the time of death a person is a minor, that will not preclude him from making an application upon attaining majority. The same proposition of in Sarjapur explains the reason of rejection of the SLC, that as because the application was made after a period of 1 year from the date it stood rejected. Accordingly, rejection by the SLC meaning of petition set aside, remanded back to consider the recommendation of the DLC to be placed before the next available SLC.
Item 20.
Yes. DLC. The DLC. No DLC. When was the application made? Which place? 25.
25. One.
Place it before DLC. Then if placed, give us the rejection. Yes, your Sharma. The father of the petitioner, Robiram Soikia, was an employee in the Bongaon Girls High School, Madhuri, to died in harness on 25/7/2077. And on his death, the petitioner made an application for compassionate appointment through the headmaster of Bongaon High Secondary School. And the vernacular version of the application available at page 26 also contains an endorsement by the headmaster that it was forwarded to the inspector of schools of Jorhat following the needful. Grievance raised is that the application was not placed before the DLC. Under the law, there is a requirement of any application of professional appointment to be placed before the DLC, and it should not be kept pending at the level of the inspector if an application is made. Accordingly, the application of the petitioner, page 26 and etc. 3, dated 25/10/2010, be placed before the next available DLC of which district? Majuli or Jorhat? Of Majuli district. And now I think it will be Majuli.
21.
Yes. Yeah. What is this? Compassionate. Where is DLC? Where is DLC first? Is the 24A. Where is the petitioner?
Your Lordship. Your Lordship, in the first paragraph, that is serial number 1. Fourth line, Your Lordship.
Where is the original?
Your Lordship.
If you give type copy, give the complete type copy and not give just one paragraph here and there so that we don't understand anything. In the original one, where is it?
Your Lordship, following page, Your Lordship, 34, Your Lordship.
34. Where is the petitioner? Suman Raj.
Your Lordship,
Zero.
not following the page 34 itself. Your
34, yes.
Lordship.
Remarks.
Then,
Deceased employee and applicant submitted. So DLC recommended.
Yes, sir.
And what about the SLC?
SLC, Your Lordship, will find
Page number?
58, Your Lordship. One,
Hmm.
Your
Suman
Lordship,
Rai
last step,
Firoz.
the last step, Your Lordship, serial number
The
1.
same order. To ask somebody to issue a direction to the SLC not to reject it in this manner and take it as per law. Every matter, how many matters should we send back in this manner? Take the same like this. How is this the owner? What's the petitioner? What's the name of the father?
Abel
नाम को लोग लोगों
Islam.
UDA JMHS School Balkachar, died in 12/9/2007. Application made on 9/2/2009. This the DLC of South Salmana Mankachar in its meeting of 21/12/2021 recommended the petitioner for compassionate appointment, taking note that his mother Moina Bewa had also applied for appointment on compassionate ground on 11/12/2007 itself. But the said application was not given its consideration. But however, the SLC in its meeting of, what is the date of the SLC? Its meeting also rejected the 1/3/2022 rejected the recommendation made by the DLC in favor of the petitioner by providing that he was a minor at the time of submission of application. Law in this respect settled in so and so. That a minor is not precluded. More so when the mother of the minor makes an application for compassionate one, but which was not given a due consideration. Set aside. SLC, remand back next meeting, taking note of the law laid down in session.
22.
Yes, 22. DLC, never placed. Sorry, page number 14. What is it? What is that? Receive. Basic. Where the MSSB shall be when concept for a petition also he said if one for elementary. The same members. Father of the petitioner, Karamat Ali, assistant teacher, Gandhar Rajbari Middle School in the Karimganj district, died 24/4/2015. Application made on 15/12/2015. Grievance raised is that the said application has not been placed before the DLC concern. The law in this respect has been settled that an application for compassionate appointment is required to be placed before the DLC. In view of the above, the will place it. The district elementary education officer Karimganj to place the application of petitioner before the next available DLC of Karimganj district.
23.
Same. Sorry,
Minor at the time.
minor से देखा नहीं? Sorry, recommendation is there. Was it placed before DLC? Not placed. Only it will made an application. Give the name of the father.
Father is very
Masud Ahmed, a teacher, Sarapur ME School, Karimganj district, died in harness 4/12/2003. Petitioner submitted application for comment on 9/12/2014. Grievance raised is that the said application not been given its consideration. Mr. P. Saikal, the counsel for the Deputy Commissioner Karimganj, has raised an objection that the petitioner at the time of the death of his father was a minor. The law in this respect has been settled by the Supreme Court in Khadim, so and so. Accordingly, the application be placed before the DLC, and DLC may also take note of the legal provision provided in Khadim Sutra and pass a resolution. What order was passed? We don't remember anymore because we go one case at a time. No, what order was passed in item? Make it more simple. What order was passed in item A? We can give that order to Mr. We'll pass the same order as item A. Item 8 order will do same as item 8. Whatever is required, you help the secretary.
25.
25, yes. Page 18. Page 0. Will issue notice? No, what more can we do today? No, even if you say 2 sentences, can we pass any further order? No. So we'll hear you on the next. Mr. Decker, you can have your satisfaction of saying, but the order will be same. Notice. So we'll hear you later on. Let others also have that turn today. Adjourn to be listed next week. We'll hear it next week. Notice. So 6 months. Because we cannot pass any interim order in this part. So it's
26.
26, yes. Notice, only notice. What's just a minute, where is the interim order? Based on what is this order? No, what is this order?
Does not appear to be just and proper, and also that is the order that is third regular. And also on bottom words, there is a question of recovery steps for recovery something initiated against all those
So how can you state? There is a finding, your appointment is not proper because it is on the basis of a select list which there where no signature of the chairman was there. So how can you state? Therefore, the government is
I was appointed.
Mr. Sharma, if your initial appointment is illegal, confirmation will not legitimize it. We'll issue notice. But Mr. R. Sharma, notice 6 weeks extra obviously is.
Because
Interim order stands rejected inasmuch as there is a finding against the petitioner that his appointment is based on a select list where There is no signature of the chairman and other members of the selection committee. Next slide.
27,
27 years. Hurry up. We have to number of matters. Yes. Only notice there is no interim order. Third MSA and go there. 6 weeks.
28,
It's Mr. Khan. That's why manual is not issued to provincialize the service. Notice, notice. What did you file? 14 appeals there. You dispose of the appeal. And Mr. M. Hugan, M. Khan and counsel for the petitioner, Assembly GST or secondary. You also there, Mr. Hugan? Anybody else? The petitioners hearing were processed for provincialization of the services in the respective schools under the Act of 2017. And the district scrutiny rejected your claim. Then why did you go in appeal? So if it is in your favor, why do you appeal? Achha, somebody must have rejected. And where is the DLC resolution? Where is the statement? Page number, paragraph number. Please hurry up, Mr. Khan. We have to take up some longish matters after that. Page, paragraph 7. Okay, we'll list it next week. I'm not getting the information. List next week in the prayer, Mr.
item 29,
Notice. A.H.M.R. Church.
30 for application,
You are appealing? CGC. Private respondent, they raised the post 3 days. This, what is this? On request of, sorry. Adjourn of the prayer, Mr. K. Kolita, Land Council, appearing for the petition.
31,
31. Yes, Mr. AM. The adjourn of the inconvenient Mr. S. Task and Council for Higher Education Department.
item 32,
32 is. No, can you hear the matter today? If you cannot hear, don't start. Can we hear the matter today? Are you ready? Adjourn on the prayer of Mr. E. R. Pabidal, Land Council for Higher Education Department. Yes.
21st September. Item 33,
33. Sorry. Who? By whom? Mr. P. Saikyal, Deputy Press for 2 weeks time to file the affidavit in office of prayer. Similar prayer on MSN for the elementary education department.
34,
34. You are appealing 34. Yes. What is the matter? Yes, respondents who appear, you appear. Can we hear the matter today? They have to find. Item number 34. No, but they have to expedite the hearing. Okay, MSN Fukan non-counsel for the elementary or secondary. Please for 2 weeks time to file the affidavit of opposition. It is noticed that this is a matter which is pending for more than a year. The affidavit be positively filed before the next returnable date of this conference.
Nice. 35 to 37.
35 to 37 years who is appearing. You are appearing in 35, 37? Yes. It's stated that Mr. B. Chaudhary learned counsel for. We'll continue with this. It's to say Mr. B. Chaudhary learned counsel for. BTC is having some medical inconvenience. John, list on so interim order to continue. We're continuing the interim order.
Only item 35 and 37. Others, they're absent. Only item 35 and 37, the interim order.
Okay, 35, 37, interim order continue.
And that's one point. It's a order date and mistake. If that's one order rate, then it's from 20 to 23.
Where?
In this order.
Which order?
Oh,
judicial order application. We can't correct it. You will say judicial order.
38 orders.
Like these matters also come up on 9%.
Nice. Yes, next step. Mr. Islam, what is this? Service complete. Who is appearing? Adjourned for 2 weeks for filing affidavit on the prayer of Mr. SMT Chisti, land counsel for the secondary education.
39.
Everything is open available. You just take it. Yes, Mr. Ho. Contempt. Notice issued. Who appears for the contempt? Who? You to wait. It's stated that Mr. N.G. Khatonia, land counsel for the respondent contempt number so and so is having some inconvenience. This conference.
40.
Yes, I for what purpose? None appears for the applicant.
41.
None appears for the petitioner.
42.
Yes, Mr. Sharma. You wanted an upgradation. Sorry. It's a contempt matter. What to be done? Who appears for the contemptors? No. Who appears for the contemptor? Mr. Sharma, you are on your merit. We're asking you who is appearing for the contemptors. Has notice been served? Then how can you proceed without completion of notice? It's a contempt petition. It's another writ petition. Sorry, Mr. Sharma, notice is yet to be issued. It was listed on 25/8/2023. None appears for the petitioner. List of the police. That's the only order. So which order is violated? Page number 21. Where is the direction? Directed to pay the pension to the petitioner as per the last page. And order communicated. Did you communicate? Third, Mr. Sharma, notice 66 extra copies. The steps were registered for 3 days.
33.
Yes. Page number. Page number 16. Where is the direction? Okay. have you communicated?
Yes.
Where is the communication? Page number. Page number. This is not a communication. Just giving the front page of a certified copy, photocopy is not the petitioner may. This contempt petition is instituted for alleging willful and deliberate violation of the order dated 14/3/2023 in WPC 1122/2023. But it is noticed that the order impugned had not been communicated to the respondent containers. Contempt petition is not maintainable at this stage. However, liberty remains to file afresh after service, after communicating the order which is alleged to have been violated. Next. It is not on record. It is not on record, Mr. Bob. We have given you liberty. Enclose it on file.
45.
Yes, Mr. Pulita. Which order is violated? Page number. Where is the direction? Para number 7 is I have heard the council. Para number 7 is I have heard the learner council. Mr. Council, I am asking you, where is the direction? You say para 77. Para 7 is I have heard the learner council, nothing beyond that. 9. Say that. Just 7 to wrong. Have you communicated?
Yes,
The number is 66. Maybe. If you had violated while in office, then Pritam Seke is not the person. The petitioner seeks for adjournment to incorporate necessary correction in the cause title of the area of condemners.
46.
Yes, madam, where is the order direction? No, where is the direction? No, where is the effective order directing? Petitioner is directed to file an appeal before the secretary. Where is your appeal? Page 16. Have they received it? No, Hannah, have they received the appeal? They did not receive the appeal. Service was not the appeal. Appeal or copy to respondent of dissent and dissent for the endorsement code. I heard your name, madam. What's your name? D. Dutta. Heard MS D. Dutta and counsel for the petition. This contempt petition is instituted alleging willful and deliberate violation of the order dated 26/8/2022 in WPC. Two 352/2021 linked with WPC 1663/2020. The effective The relevant paragraph of the order is extracted as below. A reading of para 6 of the order makes it discernible that the petitioner was directed to file an appeal before the Secretary Elementary Education Department within 15 days, and thereafter on receipt of the appeal, the Secretary to give a hearing to the petitioner as well as the respondent number 8 therein in person, and upon verification of all the relevant records to pass a reasoned order within 2 months. The appeal filed by the petitioner is on record as Annexure 2, page 17 to the contempt petition, wherein there appears an endorsement dated 9/9/2022, which gives an indication that the appeal has been received in the office of the Secretary. Be that as it may, the petitioner to serve a fresh copy of the appeal dated appeal available at page 17, Annexure 2 to the writ petition before the Secretary to the Government of Assam in the Department of School Education. And upon the appeal being submitted, the Secretary to positively pass a reasoned order within a period of 1 month from the date of receipt of the order. It is the Secretary of the Department is put to notice that otherwise a contempt had already been committed as the earlier order was not compliant. But however, taking a lenient view, another opportunity is given. Next time, straight contempt. Right.
37.
Yes, 37. Where is the direction? 16. You have not been paid provisional pension. Have you communicated this order? Page 18. Heard your name? G. Ulosco, Land Counsel for the petitioner. This contempt petition is instituted alleging willful and deliberate violation of the order dated 19/4/2023 in WBC 707/2020, wherein in paragraph 9 it had been noticed that the petitioner had not been paid even the provisional pension or the DCRG on account of some wrong fixation of pay by the respondents. Accordingly, a direction was issued to the respondent authorities, particularly the Director of Pension as well as the Director of Elementary Education Assam, to take appropriate steps on the basis of the declaration made in the said order, so that the petitioner receives the arrear pension, regular pension, as well as all other pensionary benefit. It is stated that the said order had been communicated to the Director of Elementary Education as per Annexure 2, as well as with a copy of the same to the Director of Pension. It is stated that even after communicating the order of the court, which is a specific declaration on the entitlement of pension, and further, note it had been taken note that even provisional pension had been not paid. People sentence.
Although it would be taken note that even provisional pension has not been paid.
So,
So,
as even the provisional pension had not been paid, both the Director of Elementary Education Assam and Director of Pension to remain present before the court on so and so. A copy of the order be made available to the Learned Counsel for the Elementary Education Department, as well as to the Learned Counsel appearing for the Pension Department.
Item 48.
How will the retirement survive? Has the director ever thought of it? If you have difficulty in giving regular, court said, give at least the provisional pension. Or you expect this man to go to the street with a begging bowl? Yes. Interim order. In internal petition shall be allowed to continue. What happened?
Thereafter, the director takes permission that which
From wrongful director to inspector, including you are taking an action for compliance.
But the documentary is not allowed.
Right? A copy of the contempt petition we made available to Mr. S.M.T. Chisti, then counsel for the Elementary Education Department, Secondary Education Department, to provide the information to the court as to why the Inspector of School, Sibsagar, is not doing the needful in spite of the interim order of the court being communicated to him with a direction to take necessary action by the in charge director of secondary education. This next week.
Article 49.
49 yes. Paragraph 24. Paragraph, page number. Page number. Where is the direction? Have you communicated? Page 60. That's petitioner, notice 6 weeks, page 3 days.
50.
Where is the direction? Sorry. Directed to file appeal. Where is your appeal? Who is in charge of this appeal? Section 14 appeal? Director. No. This section 14 appeal. Which official is heading that appeal board or appeal committee? Director or secretary? No. A direction will go to whom? Director or secretary? Mr. Chisti, who is heading this appeal committee? Secretary. Third, Mr. K. Padgiri, led counsel for the petitioner. This contempt petition is instituted alleging willful and deliberate violation of the order dated 9/9/2022 in WPC 5903/2022, wherein the following order as extracted was passed, para 534. A reading of the order makes it discernible that there is a direction to the petitioner to file an appeal under section 14 of the Act of 2017. And thereafter, the appeal committee to give a personal hearing to the petitioner as well as to the respondent number 6 therein and pass a reason order. The appeal filed by the petitioner is available as Annexure 13, page 43 to the writ petition, which also contains an endorsement of the authority that it was received on 16/9/2022. But the allegation raised is that the appeal had not been given its consideration, considering the nature of the grievance raised, the contempt petitions and disposed of, directing the secretary to the government of Assam in the Department of School Education to give immediate consideration to the appeal of the petitioner filed pursuant to the order dated 9/9/2022 in WPC 5903/2022, and after doing the needful as indicated in the order, that is giving personal hearing to the contempt petitioner as well as to the respondent number 6 of the writ petition, and verify the record to pass a reason order within a period of 1 month from the date of receipt of the certificate copy of the order.
51.
Yes, 51. Where is the order by assembly? Sorry. 7. When did you communicate the order. This contempt petition is instituted alleging willful and deliberate violation of the order dated 7/6/2023 in WPC 184/2019, wherein there is a direction to the authorities to do the need to take the required steps and to do the needful to finalize the pension of the petitioner within 2 months from the date of the order. By the communication of 15/6/2023, the Director of Secondary Education Assam was communicated with the order of the court. Allegation is that the pension has not been paid to the petitioner. A copy of this order be made available to Mr. S.M.T. Chisti and counsel for the Secondary Education Department to inform the court as to why the director is not doing the needful to finalize the pension of the petitioner. List on next page. A copy of their contempt petition to Mr. Chisti. What's your name? Do you appear in this case? Your name appears. Yes. Mr. P. Sonwal and counsel for the petitioner states that there is an instruction from the writ petitioner not to proceed with this writ petition in the present form any further. In view of the above, writ petition stands closed on not being pressed. However, liberty granted the petition to approach again if so advised.
53 for motion.
So what do you do? I think that matters. CRCC. Reasonable time is quite reasonable. How much?
1 month because it's from the state of Assam.
Understand? See, very well. But
Already
they also need some time also. It's not that you pack your bag and go there right today tonight. Give them 15 days. Or maybe some half-done work was also left in the other post. 10 days. Okay. It is stated by both Mr. K. Chaudhary and Senior Counsel for Petitioner as well as Mr. P. Naik and Counsel for SSA as well as MS and Fukan that in the meantime the advertisement dated 12/5/2023, which was relied upon in the writ petition to make out the legal right to the petitioner had in the meantime been withdrawn. In view of the above, no further order is required in the writ petition. But however, as a withdrawal of the writ petition would also require the writ petitioners to move out from the present post to their parent posting. Window of 10 days time be given. Accordingly, 10 days time allowed to the petitioners to do the writ petition disposal as indicated.
Item 54.
54 is
So my only verification, online verification was done. Signed by Deputy Commissioner, found by Director General.
Kumari.
Provisional admission, do not read the summary. Now you are watching few orders are being passed by your order. Now these what has happened?
Mr. Bora, where is Mr. RM Das? I think we require the secretary of the department to remain present.
Yes, probably yesterday.
Mr. Das, we list it on the same. No.
So not the first few orders. The class has started from first. So there are few orders which was passed by your also. Let me attend the class. That's what your also has passed the order. And that will be
No,
something.
in fact, we intend to form all the repetition. Why we are saying? Other day we have gone through all the documents. In Assam, Tea Garden labor community and ex-Tea Garden labor community are declared to be OBC. as per the notification of the central government. That is at serial number 24 of the notification. That notification is worded in such a way, tea garden labor community and ex-tea garden labor community as per the list enclosed. Okay. That list contains about 76 different communities. So, two conditions are required to be filled up to be included in this community. That firstly, you should belong to that community. Secondly, you must also be in some manner, at least the ancestors, be related with the tea labor, occupation of tea labor. Only these two conditions are satisfied. Now, what is happening is that list of those 76 communities are now being interpreted by many deputy commissioners, etc., to mean that if anybody belongs to that community, some Boria community, Baria community, and all different, anybody belonging to the Baria community is given the OBC. Because why? It is as per the included list of 76 communities to clause 24 of that notification. There are many instances where people from Baria community from outside the state, either one or two generations, have migrated to Assam and living here. But they are no way connected with this occupation of tea garden. Perhaps the first condition is not satisfied. And these are certificates and output of that misunderstanding of the provision of law. So we have called the secretary of this Social Justice Department or something, who is presently. Will also deliberate him regarding his understanding of the law. Then direct him to take up all these cases, put up that Madhuri Patil community, constitute immediately, take up all these cases within a period of say 7 days or so, take a decision, final decision. If the final decision is still in your favor,
Only what you're watching as the CKs return again. No, I have what you're watching as kindly for a moment try to see the order pass. Exactly, you're watching the same thing.
Suppose it goes against.
Then you automatically I'll be out.
Then who will be in?
So whoever deserves, that's why you're watching us pass this order.
But this is not 2021. This issue had not gone to that extent in 2021. Fixed Monday. So we list on Monday. We'll give a hearing on Monday. No, Monday that matter is fixed. Where you call the secretary. Doesn't matter. We have taken note of. We have taken note of your legal issue you're trying to raise.
Your lordship is just for my consideration. Your lordship, I think, is a perfect order which was passed. Your lordship, what has said?
Mr. Das, that was perfect in 2021, which is not so in 2023.
Now the lordship is saying that we will move as per Madhuri Patil.
No, Mr. Das. In the meantime, we have got some feedbacks that these orders are creating a problem. Once this man is provisionally in, he is occupying one seat, and he is depriving the other legitimate person who will be entitled, who will be below the last of the entry. That man is forever prejudiced because the last date of admission is 30 September or something. Once 30 September is passed, this person is provisionally in, then the next submission comes before us, take a compassionate view as I am already in, the next man cannot get in, even if I am illegally in, allow me to continue. Understand? So, Mr. Das, if you insist, we can give reasons and reject it for the time. We can give our reasons and reject it for the time. So, but this issue, we are getting it settled within 1 week. Because whether persons belonging to any of those 76 communities who are no way connected with the tea garden labor occupation came into Assam for the last 1 or 2 generations. By virtue of clause 24 of that notification, whether they can also be included as Tigada labor family. It's a serious issue, Mr. Das. Not only for medical, other day some Navodaya school came before us saying the same thing, that we are having a problem. Courts are giving provisional admission, we are giving. Now we are neither here nor there. Let us settle it. Let us finally settle it. If you are entitled, you are getting.
Someone will be there. And if the lordship continues after Monday, then I should be given a chance.
If necessary, we will continue on getting a Tuesday.
Yes, that's the only chance will be given.
But before that, we want the secretary of the department.
Minor, that is what matters. Now this minor from June 2022, there is a bifurcation in this.
We understand, therefore, we,
Now,
Mr. Kaur, you are 1 day behind. This submission was already made yesterday. We have taken note of this kind of submission. Therefore, requires the present department person to remain. So your problem is also addressed. So just ensure it, Mr. R.M. Das, that the secretary comes on Monday. Because if he doesn't come, we have to pass the most rigid orders.
I understand. Whenever the client answer, what is the proof, whether you are normal, whether you belong to that key community or not.
No,
That's the whole
this is
problem.
going on for the last 2-3 years.
Right?
And not only for medical seats, for every institution it is coming. So let us trash it out finally. Either this way, that way, whichever way it goes.
Only a chance will be given, and if it continues, then I will just.
Definitely. And these how much? 7, 8.
But Monday I will not. There are other cases that are-
We'll take a final call before 30 September.
Orders they were getting 155.
That professionalization matter.
I think we heard it Monday.
I wanted that particular letter, by which I was suspended on the.
Huh. Because in one line it is written terminated, in another it is written suspended. So, so what is the language in the original order? বরখাস্ত বরখাস্ত করিব লাগে is বরখাস্ত Mr. Chisti বরখাস্ত করিব লাগে বরখাস্ত হল না বরখাস্ত অন্য হল that is again another big order বরখাস্ত করিব লাগে we understood you. Mr. SMD GST and Counsel for the Secondary Education Department, as required by the order 28/8/2023, has produced the orders from letter dated 23/10/2007, by which the writ petitioner Umalota Doloi Pegu was either terminated or suspended. What is produced is a resolution of the managing committee, which contains an expression that the writ petitioner Umalota Doloi Pegu is required to be terminated, which is written in vernacular Assamese. So, no, don't read the whole thing. Ultimately, what it provides. Where is this letter dated 23/10? It is not there. It's not a letter. So, from where did he pick up the word letter then? If it's a resolution. So definitely this word expression must be appearing somewhere because otherwise I don't write incorrectly.
Just one SMC letter is
Letter. Okay, anyway, letter resolution doesn't matter. So then what happens? Now who will issue a termination order? The resolution of the SMC. Just Mr. Kaushik, Mr. Goswami will hear you, don't worry. Now, what is the procedure? Who issues the termination? The SMDC by resolution or by on the basis of the resolution by some further order or something? No. Please, the question. I'm asking you the procedure, find out whether even if it is a venture school, what is the procedure? The resolution itself is the final document for termination, or resolution is a basis for a termination and to be followed by a formal order of termination. So is there any formal order? Because he says it is not there. Has produced a resolution or the variant. There is an indication that a decision was taken to terminate Lota Doloy Pegu. In the circumstance, an issue would arise as to whether in a venture school, the resolution itself is the final decision of a termination or the resolution would be a basis for issuing a formal order of termination. Mr. Chisti, please from the gentleman to provide the information. Yes, what do you want to say?
Sir, under the Assam non-government education institution regulation, now if this is now one no employee of a non-educational non-government education institution can be terminated without an inquiry.
Mr. Goswami, first check out whether a venture LP school, whether a venture LP school is included in that act.
In fact, there is a decision of this High Court also where they said that this provision has to be.
You're very decision.
Before I take a logical decision, first the lordship has to release that at what stage I have approached your lordship. My advance before your lordship is that I am not included. Now, if you include an employee in that list, there are a verification stage. Now, this is like 2-3 tier verification stage, but at first the district scrutiny committee will have to verify. Now, here they have to verify the records of the lecture that has been said. So my case is that in the case of the petitioner, first of all, the records has to be verified. Simply say,
Mr. Goswami, that is a part of the provincialization proceeding.
correct.
We are not on that. First, let us
But in order to
first
vary,
understand. First, let us come to a conclusion whether the person was terminated or not terminated.
absolutely. Your lordship
Because-
will kindly have page 59.
Because the basis of your argument is that I was never terminated.
No, I was never. In fact,
So we have to verify it.
kindly come to page 59, that is our High Court record.
What the remains? First,
Let
we
them verify and produce the entire records.
the respondents will also produce the complete records relating to the termination stroke non-termination of the requisition. Respond when you are. If you are still there, we'll look at it from a different point of view. If you are terminated, it will be an offense. So first, let us settle that.
Very well. Because we have never at any stage.
Understand?
It's 6 for orders.
At that time, she was absent and she was happy. Because she came.
Madam Devi, suppose tomorrow you remain absent in the court and we dismiss for default, will you not become a lawyer thereafter anymore? You'll continue to remain a lawyer.
No, my lord, actually.
It will be absence of that given day.
They actually seeking several times before this allowed.
Everybody has the right to respond to their own legal right. Yes, Madam. Devi. This matter, item 56, what is to be done today? MSR Deccan Land Council states that she has instruction to appear on behalf of respondent by E and intends to file and file appropriate affidavit on behalf of the state respondent. Prayer law. On this after. You take your date. Whichever date you want. It has to be continued, not absolute. Interim order to continue till then. Yes, next. 2015 matter. What is this? Mr. Viswas, what is this 15th matter?
In Contempt college. The defense of the petitioner in this petition is that she has not been promoted to the selection grade of pay from senior scale grade of pay. And
Senior selection not promoted.
yes, her case was not being forwarded by the principal of the college to the DPC for have not initiated the process of promotion. Whereas my lord, by the same order, the petitioner and one Montu Sekya was appointed in the senior scale of pay of the same day by the same order. The case of Montu Sekya was considered, the case of the petitioner was not considered.
Mr. Viswas, first tell us, suppose both of you are entitled, both of you will get the selection grade, or only between you two, one of you will get it?
No man.
Both. So it doesn't matter what happened to Montu. We'll only examine your legal rights. Okay.
Now,
So your allegation is that your papers were not forwarded by the principal to the DPC. DPC of who's DPC? The college DPC or college DPC?
now, my lord, the reason which the principal is citing, my lord, is that, my lord, after my appointment and after my promotion to the senior scale, my lord, I was terminated from the service. On the
Who appears for the principal? You appear. Okay. Your principal's view is that your services were terminated.
terminated, my lord, and I am again reinstated because the termination was challenged by me in this High Court, my lord, and the High Court has set aside the termination order and have directed my reinstatement with a specific rider that my services will be construed as if I am continuing the service. So there was a specific direction from the High Court.
So now where is the termination? Where is the High Court order? Let us
So,
find out.
because since the termination, the High Court order, I'll take your, my lord, I'll take your lordship to the High Court order.
Page number.
Page number 20.
Page number 20. This is by Bornali Decker.
Yes, same.
The same Bornali Decker. This order is dated
Yes. Order is
28/2/2013.
absolutely.
And regarding some cost, some
Yes.
issue was there.
Yes, my lord. My lord, may kindly come to para 28 of the judgment, my lord.
28 for the 4-seat revisions. So now where is the stand of the principal now?
My lord, the principal says,
No, where is the stand?
the stand of the principal is in the activity opposition.
Page number.
Activity opposition, page number, my lord will see. He says,
Where is the page number?
page 3,
There is no page 3. Take out the running page number. Yes, next text. The petitioners to take note of the running page number. We adopted this procedure to shorten the time of hearing. Otherwise, you take about 5 to 10 minutes to locate one affidavit. So the registry is also directed as a judicial order that every case will contain running page number if there are multiple pleadings, and I think after the change of the room, it is not there. One notice was also put before all the running council. Take note of the running page number. But otherwise, anyway, what the petitioner standard principle?
Principal stand is that, my lord, that my caste issue is that he writes something very strange. He says, my lord, the principal says that my caste issue is pending in terms of the order of the High Court. High Court say that principal cannot.
Mr. Bora, ask your client why we should not issue contempt notice on him. No, just ask your client why we should not contempt notice to him. If he wants, ask him to rectify immediately before the next day. Or if you want to contest, we'll hear you, but the consequence may be even more severe. We are giving you an opportunity. Rectify, do the needful before the next returnable date. If you want to contest, we'll give you a complete hearing. Maybe more than one day also if you want. But if the decision goes against you, your principal will be in big trouble. We are indicating it. So either you contest, we'll hear you, or you do the needful and tell us before the next returnable date. You can adopt both. You can adopt either of the two. You don't have to say anything today. See, when there is a specific judgment of the High Court that a termination is set aside, meaning thereby that the termination order does not exist in law. Plus, High Court is more specific that he will be reinstated and as if he is continuously serving. Based on this information, if you are required to place it before the DPC, place it before the next returnable date. And if you want to argue your matter, you are still welcome. But if your argument is unacceptable in law, consequence will be, we'll drop a contempt against your man. So ask him to think and tell us.
Yes, Dr. I respect my claim, but he is not correct as per record. It is promotion.
Mr. Bora, we have read one report, that is the judgment of the High Court.
Yes.
And the High Court judgment we have not wrongly read.
No, from that judgment also we have
You cannot interpret a judgment and take a different view. Judgment specifically sets aside an order of termination.
Yes.
And the meaning of setting aside an order of termination is termination order does not exist in law.
Yes.
Meaning thereby that the person is continuously serving. And you cannot give any other interpretation. If you give, you are welcome, and we'll also decide it. Send it immediately. Don't play with this teacher's life. Just because you don't like the face of one of the lecturers. Don't do it. And don't make it an ego issue for the principal. If he makes, he'll have to face it also. High Court order is very clear, Mr. Bora. There is no scope of interpreting. See and find out the reasonings and the factual aspects taken note of by a court in arriving at a conclusion cannot be made a basis by anybody else to give a different meaning and interpretation to the judgment of the court. That is the law. This goes against you. That's why you are saying. I know you are trying to say something very attractive, maybe, but that will not help you. We can foresee it. After reading, consider, send it immediately to the DPC. Producers will close this petition. DPC may do anything, but not the principal. If he is not entitled, DPC can reject him. That's a totally different matter.
If it is already sent to the DPC, I will file it.
No, you did not file affidavit also. It's a 2015 matter. You just produce us that document.
Okay. I have no instruction today. It is already. I think it is already.
Otherwise, they trying to take advantage of the reasonings in a order of the court to take a different view is also a contempt. read the law of contempt. Don't do all these things. And if you don't like the High Court order, file an appeal. Yes, Mr. Gobi. Just say something.